The awareness has been very low, to say the fact. In fact, sometimes you have to try and convince many judges to say this is an innovative provision of the law. And some judges are also very reluctant to go by those new provisions. These laws that they just brought from somewhere as if it wasn't meant to be implemented. So some will find it extremely difficult. But sometimes when you now say senior presenting this argument in a nice way in court, at the end of the day, the court will accept it and allow it to stand. You know, prior before now, I know that I tried sometimes in federal court in Lagos to activate the provision of Section 32, which is in line with our own Section 44 in the Abolition of Criminal Justice Law, that says that where somebody has been kept in custody for more than 24 hours, you have the right to approach the court. I raised it orally before a federal court in Lagos. They said, no, you cannot do that. They said, go and put it right. I have to put it in writing, motion, reply, and all of that. At the end of the day, it was activated. So it will take time, actually. And lawyers should have the courage to move away from the status quo. Because this is an innovative, the provisions are so audacious, they are innovative, and they need to be respected. Because this is law. Like I said when I was delivering that particular lecture, it is when all of us respect the rule of law that everybody will be safe. Because everybody is a potential suspect. Everybody is a potential suspect, and the charges can be unduly brought against you. Because we have seen a situation where somebody was actually coming from a PhD research back from his country, from outside the country, during that night, he was picked up. He was picked up only for the police to be apologizing later on to say, we didn't know that you went for. Somebody was just coming directly from abroad after finishing his PhD to come and serve his country back. So that means that everybody, whether you are a suspect today or you are not a suspect, you have a duty to see that the provision of the law is applicable, is applied effectively. Because at the end of the day, if you feel, okay, yes, you look, sometimes I tell some of these law enforcement agencies, okay, apply the law in such a way that if they apply it to you, you will see that person as being fair. And that is the purpose of application of criminal justice law, to ensure that fairness, justice, equity, and equitable treatment of everybody is put in place.
Judging the adherence to the provision of the ACJL by our courts on the scale of 1 to 10, well, I'm going to give them 8/10. Yes, because from practice and experience, our judges, whether from the inferior courts to the high courts here in Kwara State, they make every effort to ensure that their procedures are in line with the administration of criminal justice law of Kwara State.
The administration of criminal justice law is a very robust law that made a lot of new innovations having to do with seamless and speedy trial of cases, and a better treatment of suspects, their rights, and the victims of any offenses. But in a whole, we can say that the implementation has been a major problem. What we have now is a scattered implementation by individuals, not a coordinated one. Because to have a coordinated implementation, we must have administration of criminal justice monitoring committee on ground. We must have designation of magistrate and chief magistrate to visit police stations to ensure that inmates are well treated and civil matters are not turned criminal, and discharge whoever is not supposed to be in detention. So all this put together, we can say maybe just about 2/10 is the level of implementation, because without those institutional coordinated way of implementing it, it will be very difficult. So what I've been doing now is an individual, probably a few of lawyers, trying to assert the right of their clients through what has been provided by ACJL.